Thanks for coming tonight to our business policy debates or conversations and dinners. We started this program some time ago, and it's joint between the CGM at Anderson and the Milken Center at the law school. And it's an opportunity for students from both of these schools to get together and discuss some of the most important current policy issues in the world that any business or legal leader in the world should be, we think, aware of and be able to develop opinions on. We've had several of these already. The first one was on immigration. It was very successful, and that gave us the impetus to go forward and continue the series. The second one was on Bitcoin, and when we sent the invites, it sold out in 1 minute. Then we heard that there was a secondary market for seats and that students were selling their, and some students that were selling were actually demanding Bitcoin as pay. As the date of that one approached, Bitcoin, or some of the Bitcoin people were indicted, and we didn't know what was going to happen. And if we had to cancel, who was going to eat all the chicken that was had been ordered? Then we had another one on high-frequency trading, which was also very successful. And now we're very happy to talk about green chemistry, an issue that, of course, is of great importance all over the world. I'm on the board of a mining company, and our main concern, all we talk about actually, is the environment and green issues. Well, we also talk a lot about safety. We don't talk about the price of silver or gold because they tanked and it's depressing. So we just ignore those because, of course, we're losing money. But our main concern is miners should be safe and the environment should be safe. And I've been on this board for now about 7 years. And when I joined the board, we devoted a grand total per board meeting of maybe 7 minutes to safety and the environment combined. Now we spend all the time. One of our competitors had bought a mine, which is a very interesting one. It's a gold mine in Chile, up in the Andes. But it's on the border, and it's very hard to get the mineral back to the Chilean side. So this is Barrick. It's a very well-known case. So they built a tunnel through the Andes to the Argentine side. So the gold is mined in Chile, and then it is sent down this shuttle down to Argentina where it is processed. And after they invested about $1 billion, it was stopped because they didn't have any green chemicals, and they were damaging the environment on both sides. And Barrick's shares have tanked since. So it's a very, very, very important topic. And I am thankful to both of our speakers. Joel is going to introduce them, so I'm introducing Joel, but I'm getting carried away. But I want to recognize and thank Professor Timothy Malloy from the UCLA Law School, and Professor Steve McGuire from McGill. And I'm sure that we're going to have a great conversation. So I thank you again for coming. Joel Fewer is the Executive Director of the Lowell Milken Institute. He is a former partner at Gibson, a very important, prestigious law firm, and he has a very long experience and was the general counsel for the firm, and we are very, very fortunate here at UCLA to have him with us. Let me just end by just two miscellaneous topics. I'm drinking a drink that is 70% juice, it is said. I don't know what the other 30% is, but wish me well, and that I think is maybe it's part of the of the environment problem that we don't know. And again, let me just emphasize the end, the purpose of this is that you have an opportunity to talk among yourselves and discuss the issues that we have, that our two guests are going to discuss. So Joel, thank you very much, and please, thanks everyone.
Thank you. So good evening, and thank you for coming. You can see our topic is business law and green chemistry. I have to admit that when I first heard about green chemistry, I had heard the term once before. I really didn't know what it was, but I was excited because I figured, oh, good, we're going to see a chemistry experiment. Maybe something will blow up, which is the only thing I like about chemistry. But I don't think we're going to have that today. I think what we're going to hear about is what you expect. That is, we're going to hear about business issues and legal issues. And so it's very fitting that our presenters are someone from a business school and someone from a law school. Because I think what we're going to hear and what we want you to think about are the challenges that companies face in trying to develop and to adopt sustainable technology. And there are many challenges, and it's often more difficult than we would like it to be because, of course, in general, people are in favor of developing sustainable technology. I want to introduce both Professor Malloy and Professor McGuire. I'm going to, even though I wrote this out for Professor Malloy first because I know him, I'm going to start with Professor McGuire because he's our guest from McGill. Dr. Stephen McGuire is an associate professor of strategy and organization at Desautels Faculty of Management at McGill University. He teaches in the core of the MBA program, Markets and Globalization, as well as elective courses on topics related to his research, strategies for sustainable development, managing organizational politics, which I think we're going to hear about some today. He also conducts seminars in the executive education programs. Dr. McGuire was appointed as the inaugural director of the Marcel Desautels Institute for Integrated Management in August of 2011. He holds the Desautels Chair in Integrated Management and is also an associate member of the McGill School of Environment. Dr. McGuire is an internationally recognized academic in the field of organizational studies, where he made significant contributions in the areas of institutional entrepreneurship and organizational discourse. Empirically, his primary research focus is on institutional and technological change driven by the emergence of new risks to human health and the environment. Specifically, he seeks to understand the fates of particular technologies, that is, whether, how, and why they are adopted and enter the economy, whether, how, and why they are abandoned and exit the economy, and how this is influenced by the activities and strategic behaviors of non-market actors, such as non-government organizations, scientists, politicians, and governmental organizations, in addition to the market factors, such as the firms, the companies, and their customers. He is known as an expert on the precautionary principle in chemical risk management and was appointed in 2007 to the Government of Canada Chemicals Management Plan's Challenge Advisory Panel, which advised Health Canada and Environment Canada on the screening of some 200 high-priority substances. He is currently working with McGill's Department of Chemistry and other institutions to expand green chemistry into business schools. His work was awarded the prestigious Academy of Management's Organization and Natural Environment Best Doctoral Dissertation Award in 2001. He has also served as a peer reviewer for the United States Environmental Protection Agency's Office of Prevention, Pesticides, and Toxic Substances. So you can see we're very, very lucky to have Dr. McGuire here with us. And let me also introduce Professor Timothy Malloy. Professor Malloy teaches at UCLA School of Law. He teaches environmental aspects of business transactions, regulatory lawyering, regulation of the business firm, environmental policy and politics, and contracts. With Dr. John Froines of the School of Public Health, Professor Malloy is the faculty director of the interdisciplinary UCLA Sustainable Technology and Policy Program. After receiving his law degree, Professor Malloy clerked for Judge Donald Van Arstendale, the U.S. District Court of the Eastern District of Pennsylvania. He joined the UCLA faculty in 1998 after spending 11 years in practice at private firms and at the United States Environmental Protection Agency. His research focuses on the environment, chemical and nanotechnology policy, regulatory policy, organizational theory, and decision analysis, with particular emphasis on the relationship between regulatory design and implementation and structure of business organizations. In addition, he has worked and written extensively in the area of risk governance and prevention-based regulation, melding together his academic interests with his work in the Sustainable Technology Policy Program. And let me just take a moment to talk about that program. It's here based in UCLA and champions public health and the environment by seeking to challenge the way our laws deal with chemicals. It's a joint venture of the UCLA Law School and the UCLA Fielding School of Public Health, and brings in collaborators from throughout the university and the larger community. It works to identify and promote the use of safer alternatives to hazardous chemicals found in consumer products and used in industrial and agricultural production. So between the two of them, I hope you've heard some themes, because I think these themes are going to play out tonight in our discussion. The way we're going to handle the discussion is Professor McGuire will go first and make a presentation. He will be followed by Professor Malloy, and then I will moderate a Q&A session. So think about your questions, because we'd like for you to ask questions. And then at the end, as we sit down for dinner, as dinner is served, we'll put 2 questions up on the screen, and we hope that each of you at your tables will discuss the questions. And during dessert, I'll walk around with a mic and ask one person at each table to stand up and talk about what you discussed at your table. So if we start with Professor McGuire.
We have green chemistry mentioned a lot in our presentation this evening, and so I thought I'd begin by just setting the stage. Who can tell me what is green chemistry? Who would like to take a guess at what green chemistry might look like? Surely lawyers and business students aren't shy. Yeah.
I'm going to say non-harmful, green energy, or disposable material.
Good, excellent. You're exactly right, non-harmful. Green chemistry is a set of design principles applied by chemists and chemical engineers that reduces or eliminates the use or generation of hazardous substances in the design, manufacture, or use of chemical products. Now that sounds quite straightforward, but it actually is a potentially radical approach to chemistry. Why is it radical? The traditional approach to implementing chemical technologies accepts that hazardous substances, toxic substances, harmful substances, substances that might explode during an experiment, must be part of the economy. They're essential. And focuses on reducing exposure to those substances. So we'll label the containers in which we transport them. We'll train the workers who have to work with the chemicals. We'll have the workers wear protective clothing. And if we have to flush it into the ecosystem, we'll dilute it. Dilution as a solution to pollution. And that was the approach to developing chemical technologies for much of the last century. With green chemistry, that's all changing. And I'm going to talk to you today about why I think that the risk management logic, when applied in firms, can be game-changing for developers of green chemistry technologies and will help them to get those technologies adopted. So I'm going to begin very quickly by reviewing a typology of different business logics for green chemistry, and then I'm going to focus in on the risk management logic, and I'm going to frame risk management in terms of substitution. So the substitution of polluting incumbent technologies with the adoption of challenger, greener technologies. Then I'm going to talk about two concepts, risk translation and what I call the risk management premium, and then I'll wrap up with some implications. Nothing very complicated in a business school. There are two ways to make higher profits. What are those two ways? Exactly. So bring in more revenue or lower your costs. Revenue minus costs equals profits. So this is not my typology. It's one well accepted in the literature. But it basically argues that there are 7 different logics why firms might make an investment in a technology that lowers their footprint, that lowers their ecological footprint. Starting on the revenue side, so better access to certain markets. An example of this might be Walmart, which is, with its supplier sustainability program, it's now incorporated a software called GreenWorks, which basically codes chemicals in products as either red, yellow, or green. And if you are a supplier trying to sell to Walmart, you can't be selling them products that have chemicals that are coded red in them. So by investing in green chemistry, you have better access to certain distribution channels and certain markets. The differentiating products logic. This, an example of this might be Method, which makes non-toxic cleaning products. They are able to charge a premium for their cleaning products because there are consumers who want to clean their houses with products that are non-toxic. Selling pollution control technology. So a chemical company might devise a new technology, implement it itself, and then it might license that technology to some other chemical companies who are active in markets where the original chemical company doesn't have much of a presence. So the 3 ways that an investment in technology that lowers the environmental footprint can increase the revenues of a firm. On the cost side, I'll start with cost of capital and cost of labor. These are 2 indirect mechanisms through which environmental investments can yield benefits. The arguments go as follows. Firms that lower their environmental footprint have access to more capital and therefore pay a lower cost of obtaining that capital. They have access to socially responsible investment funds. They're maybe accessible for clean tech funds. And increasingly, shareholders are incorporating environmental considerations into their own decision making. The cost of labor can go down as a result of making investments in environmental technologies. The argument goes that workers in a firm that they are proud of are more motivated and are therefore more productive and therefore produce more for the same pay. In a company that has designed hazardous substances out of its manufacturing process, costs associated with illnesses and accidents can go down. And it's easier to hire the top white-collar talent, chemists, lawyers, business people who want to work for firms about which they can feel proud. On the cost side, the logic that I think is the most easy to grasp is that the one on lowering costs. So if you implement a technology that lowers the consumption of energy, all those savings, you're using less energy, so you're buying less energy, so your energy costs go down. If you design hazardous substances out of your manufacturing process, not only you not have to purchase those hazardous substances, but the cost of handling hazardous waste, which is quite expensive to get rid of, also go down. So there's an immediate impact on the bottom line. And then the final logic is the risk management logic, and it's the one I want to spend some time on today. This is when an investment in a technology that has a smaller environmental footprint lowers the probability of a costly event in the future. That costly event might be government regulation, which increases costs or disrupts your operations because a particular chemical is banned. it might be an accident, or it might be a lawsuit. So whereas with the cost logic, the investment today yields for sure benefits today. The risk management logic, the investment today lowers the probability of an uncertain cost in the future, and that's why it's called a risk management logic. So I'm going to focus on that risk management logic, and I'm going to do so by framing what I have to say in terms of substitution. All of you from the Anderson School know Michael Porter. Substitution is the process by which one product or service or technology supplants another in performing a particular function or functions for a buyer. So you can think of it in terms of abandonment and adoption. So substitution occurs when firms abandon an incumbent technology and adopt a challenger technology using an economic calculus. The theory that I present here comes directly from microeconomics. Substitution occurs when the challenger technology has a superior performance per unit price, or relative value to price. So if we make the simplifying assumption, just for the sake of clarity, because I want to get to the essence of my argument, that functional performance of the two technologies is equivalent, there's no switching cost, then basically the challenger is adopted when it's less costly. Quite straightforward. Now, I'm going to argue tonight that under certain circumstances, the challenger technology will be adopted even if it is more costly. Under which circumstances? When the challenger technology, in addition to its functional performance, so doing the job it was designed to do, it reduces or eliminates a risk associated with the incumbent technology. And I refer to the difference in costs that the adopting firm is willing to assume voluntarily as the risk management premium. Now, to understand the risk management premium relevant to voluntary substitution of incumbent brown or polluting chemical technologies to be replaced with green challenger technologies, one must appreciate what I term risk translation. Now, risk translation is the social process through which a chemical risk produced by an organization, so a potential harm to a stakeholder or to the environment, when that potential harm becomes translated and transformed into a business risk to the organization that is producing the chemical risk. And so firms, I'm going to argue, firms reduce chemical risks not because they want to reduce chemical risks per se. They reduce chemical risks because they want to reduce the business risks that stem from the chemical risk. So it is the business risk that drives the size of the risk management premium. And you could think of some examples of different business risks. So regulatory risk, the possibility that the government will implement regulations that are costly or disruptive to your operations. Legal risk, so the potential for a lawsuit. And then finally, reputational risk, the potential to become associated with a technology that the public is embroiled in a controversy and that paints the firm in a negative light. So the risk management premium will increase when the technology in question represents a minor component of the adopting firm's cost structure. So when switching to the greener technology increases my costs in a minor way, that increases the premium that I'll be willing to pay just to make that potential problem go away. And similarly, if I have market power and I can pass on the additional cost to my customers, that also will increase the premium that I would be willing to pay. Now, I want to focus now on reputational risk only here. and talk about some of the factors that increase the risk management premium that firms are willing to pay because of the reputational risk that frightens them, that threatens them. So if the adopting firm has a lot invested in brand equity and its reputation, so a strong brand, or if the adopting firm is explicitly differentiating itself based on ecological and health values, or if the adopting firm has publicly affirmed its commitment to corporate social responsibility, if the chemical risk underlying the reputational risk gets more media attention and starts to become more controversial, or if the chemical risk is less acceptable to the public. So, for example, those exposed to the chemical risk might be vulnerable populations, such as developing fetuses or infants, which are more likely to spark outrage amongst the public. And so, the message I have for developers of green chemistry technologies is that, yes, they should always be striving for superior functionality and superior cost as compared to the incumbent technology that they are seeking to displace. But these challenger technologies do not necessarily have to be superior in order to be adopted voluntarily by firms. Indeed, the competitive game between the challenger and the incumbent gets interesting when these technologies achieve comparable functionality and cost. And by interesting, I mean that adoption depends on debates over the acceptability of business risks inside organizations, which are in effect debates over whether a risk management premium is worth paying. And I focused my talk on reputational risk. I could tell the same story around regulatory risk because I want to end with some concluding remarks about value chains or supply chains. If you look at some of the struggle around certain toxic substances, the NGO community has gotten much more sophisticated in terms of advocating for the substitution of, the removal of hazardous substances. And they've done so by focusing downstream on retailers or product formulators who have a lot tied up in brand equity. And so if you think about the struggle over bisphenol A, for example, the chemical companies who actually manufacture and sell it are concerned about regulatory risk. In Canada, they fought hard against a ban on BPA in baby bottles. At the other end, the retailers, what they're concerned about is reputational risk. And if they can stock their shelves with baby bottles that have BPA or baby bottles that don't have BPA, you stock your shelf with the baby bottle that has BPA, there's a lot of media attention, there's controversy, there are vulnerable populations involved that can elicit outrage amongst the public. They just want that problem to go away, so they say, we're pulling the products that have BPA in them from the shelf. And so the struggle over which chemicals are in the economy and which chemicals are not in the economy has shifted from one where fighting or lobbying government, both sides lobbying government, trying to get either no regulations or regulations of a particular kind. And now the emphasis is on downstream product manufacturers or retailers, and where the leverage is reputational risk. Thank you.
Thank you very much, Steve, for that really fascinating talk. And I'm going to talk a little bit now about some additional supplemental views and also some limitations and caveats about the notion of the risk management premium. But that's meant to expand the conversation, not to critique the underlying validity and usefulness of that approach, right? But before I do that, I'd like to just thank the Lowell Milken Institute for Business Law and Policy and the Center for Global Management at the Anderson School for having us both here. And I especially want to thank my friend Steve for coming here so that he could hear us complain about how terrible our weather is, how cold we all are. It gives us a little dose of reality, and thank you for bringing us to our senses. I'm going to talk about 5 points. Let's see, that's me. Tonight, I'm just going to kind of reiterate the business logics that Steve spoke about. And then I want to shift gears a little bit. These next points that I'm talking about after that really try and get us thinking about what is it we mean when we talk about the corporation or the firm that are making the kinds of decisions that Steve mentioned. Now, when I was in practice as a lawyer, I was in private practice representing these types of companies, manufacturers and retailers, oil refineries and whatnot. So I got to see what goes on within those firms. And then I went to EPA for a while, and I got to enforce against these firms, and I got to see that aspect of it as well. And now here I am in academia where I finally get to study all that. And so what I'm about to say, some of it's drawn from my personal and anecdotal experience, but that experience was confirmed when I came and started looking and developing some of the empirical and theoretical literature about what drives firm decision making. So I'm going to talk about the firm and talk about the business risk premium, or the risk management premium in the context of this broader conception of the firm. And then I'm going to finish out with just a few suggestions about what role regulation might play in the enhancement of the adoption of green chemistry, given what both Steve and I had talked about. So you've seen this before, and as I mentioned, I don't dispute or argue with any of the logic that's up here. This all makes quite a bit of sense to me. But what I want to do is explore some of the factors, other factors that might modulate how impactful these factors actually are in the business, in the context of the interior of the firm. So Steve made 2 very interesting points. The second one that I present here is the one that he focused on. But I want to talk about both of these kind of like bookends to the talk. So the first one is when new technology performs as well as the incumbent technology and costs less, we should expect to see adoption of that new technology. Intuitively makes sense from the business logic, right? The second one is, that Steve points out to us, is that sometimes when the new technology performs at least as well and costs more, we still may see it being adopted, and that's if it reduces or eliminates this risk that's associated with the technology. Now, both of these principles are primarily focused on an assumption that the firm is a rational actor, and that the firm is an entity, a monolithic entity that actually makes decisions driven by a particular goal, and in this case it would be maximizing profits, right? That's the analysis of revenue minus costs. So I want to unpack the firm a little bit. So this is how we may typically, and when I say we, I'm not just talking about the folks in this room, but the economics and the legal literature. There's quite a bit of discussion of the firm that assumes it operates as kind of this single person who's making these judgments and responding to the public in terms of the public as the consumer, the regulator imposing requirements on them, and then the public at the bottom there is the public, the advocates, the NGOs and the other groups that are also influencing the firm. And the firm's responding to this with a view towards the underlying goal. Right? They're attempting to maximize that goal, and it may be profit maximization. It's possible that with respect to some firms, it's also the notion of sustainability or good corporate citizenship, and there may be multiple goals, but the sense is that it's acting rationally to advance those goals. I want to take a peek inside the firm, right, at a couple of different levels. So if we think about our firm, and let's just take an example. Maybe my imaginary firm, the one I'm thinking about, is a mid-level manufacturing firm, maybe medium to large firm. and they're producing perhaps some consumer goods, either electronics or cleaning products, so on and so forth. So they're kind of in the middle of the value chain there, or maybe towards the bottom there, where they're about to put these products out in the marketplace. And they need to make this decision about replacing a material in their product with a less hazardous material, or even putting funds into research and development to identify material maybe that isn't even in existence yet. And what's going to happen with them? Now, before, we talked about the firm as a person. And in fact, the Supreme Court in Citizens United, a case about campaign finance, or at least campaign advocacy, was based on this notion that corporations are persons. But I want to change that. I don't want to talk about corporations as persons, but I want to talk about corporations as people, as consisting of people. And the fact that they're made up of people means that we don't have a monolithic actor. We've got a number of people in a social network making decisions in accordance with norms and procedures and habits of that social network. At the intermediate level, we could break the firm out into upper-level management and various operating departments or units. These operating departments could be individual facilities, or they could be particular departments or divisions within the firm: engineering, product design, sales, so on and so forth. Many of these divisions are going to be generated organically because they're necessary for the firm to function, right? And we're seeing various amounts of specialization of that function and coordination, right? We're all familiar with the notion of the pin factory and Adam Smith's discussion about specializations of functions within firms in order to make them efficient. Sometimes there's functions that are imposed externally by forces outside of the firm. And one of the good examples of this is, between the 1970s and 80s, slowly, environmental regulation, we start to see new departments within firms created focused on environmental protection, now morphing into a focus on sustainability. And yet for many firms, these are viewed as, in fact, perhaps intruders or folks who are new to the game, or perhaps as necessary but not core to the strategy or the function of the firm. And that affects how well they will compete within the firm for various resources. But let's dig down a little deeper. Let's open up one of these departments or divisions, and what do we find inside? We find people inside, right? People who have to make particular decisions. Sometimes those people will be driven by goals of their own that may or may not be in concert with the goals of the firm. So the classic concern that the agent of the firm, the individual manager or product engineer, may be advancing goals of their own that don't necessarily drive profit maximization. But we also face another problem. Even if the agents within the firm are attempting to act in a way that will increase profits, that's not how their jobs are defined, right? Their functions have to be operationalized and broken into smaller tasks that, when put together with everyone else who's functioning in the firm, will increase profits. But their focus may be on just making sure that their particular task is performed well. So when we look inside the firm, we also note that these people who are making decisions are limited cognitively in terms of how they're able to process various amounts of information, right? Whether there are cognitive biases in terms of how they simplify decisions that they have to make, and other foibles of behavior that lead to, in many cases, suboptimal decision making. So I want to take one more look inside the firm now and think about how some of these factors that I've talked about might actually affect decision making about whether to adopt a new green material for an existing product. So really, when I think about the firm making these kinds of decisions, I break it down into two basic pieces that have to be considered. First, generally speaking, there's going to be a gatekeeper, someone who makes the decision about whether to pursue, investigate, and propose for adoption a change. Now, take a step back and remember, my hypothetical or my imaginary firm is one that's competing in a marketplace for customers. They're selling a particular product. And those customers are expecting a particular performance from that product. So if we're going to change something about product design, we're going to want to make sure that that change is not going to impact the competitive position. And while Steve, I think, rightly makes a simplifying assumption that green chemistry and substitution would perform as well, I think in the reality, on the ground, when businesses are making judgments about whether to substitute or not, and particularly when you're talking about an individual level manager deep within the firm, there is uncertainty about whether the performance will be quite as good, and also concerns about what will be the lag in terms of how long it will take to get production back up to the level that it's expected to be back, so on. So there are risks associated even with really replacements that appear to be quite promising. So this gatekeeper, right, before they can make the proposal within the firm to devote resources to substitution, to replacement, number one, they're going to have the information that alternatives are available. Right? They're going to have information about what's actually in the product that may be of concern. This information is diffused within the firm and may not be directly available to them. So we have concerns about the availability of information flow within the firm that would even allow the product manager, whoever this gatekeeper is, to identify an opportunity. And we've also got this issue about whether the individual's goals or the goals of the department in which they operate are actually in tune with, focused upon enhancing the environmental performance of the product. Are the incentives that are in place within the firm designed to drive decision-making in that direction or in other directions, right? So even if it turns out that someone externally looking at this would make the decision that this replacement technology could reduce costs, the person who's actually charged with initially identifying and then proposing this change may not be thinking as that's one thing that they're trying to achieve in terms of what their immediate sub-goals are. But let's assume we get past that and that the gatekeeper now has identified an improvement to the technology and wants to propose the adoption of it. Well, changes cost. Right? There are resources involved. Some of them may be quite large, some of them may be small. But the gatekeeper who is proposing a change within the firm is going to have to compete within the firm for resources in what I call the micro market of the firm for resources in terms of funding, personnel, and so on, things that would be required to make this change. Now, clearly, if we've got a technology that will cost less, right, it seems that in many instances, the rate of return on that investment may be a net positive, right? So in terms of the factors that would be taken into account, it would seem that that technology is well positioned to do well in the competition for resources within the firm. But there's other factors that we've seen in the empirical literature about how resource allocation occurs in firms that has to be taken into account in addition to the rate of return, and in fact may be overwhelming the rate of return as the factor that controls how those decisions are made. Let me just talk about three of them, and then I'll move on to questions about how could a firm possibly survive if it's passing up opportunity, right? But let's look at some of the factors that might lead them to pass up an opportunity. One might be the nexus to strategy, right? So remember, if this particular proposal is coming from somebody who's in the environmental health and safety area or the sustainability area, the question is how aligned are those concerns of sustainability with the overall strategy of the firm? Clearly in firms where there's been an embracing of sustainability as a core business value, you're going to be better situated to win in the competition for resources. But in firms where that has not taken root, this particular proposal, even though it has a positive rate of return, may be disadvantaged as compared to other proposals for the use of funds that are clearly centered on core values of the company. Also, you have to think about the relative influence of who that gatekeeper is, right? If, again, it's coming from a division within the firm that has less power and influence within the firm, again, the relative rate of return may not be enough to carry the day. And then lastly, we have to think about project category. And this leads a little bit to the consideration of would it make sense to have regulatory programs that require consideration and adoption of safer alternatives? Studies of how firms allocate resources indicate one thing is clear, that most firms, when an obligation is created by regulatory requirement, that advantages proposals to meet those requirements in the hunt for resources. That is, firms that value compliance with regulations will exempt, in a sense, these kinds of improvements from having to compete on the same basis as other kinds of investments within the firm. Okay, so you may ask yourself, all right, but if there are clearly new challenger technologies that will increase profitability, wouldn't just the discipline of the marketplace lead to a situation where those firms that don't adopt because of possibly suboptimal information flow within the firm or misaligned incentives within certain divisions of the firm, wouldn't the marketplace just eventually eliminate them and the adopters of that technology would then take hold? This is what we call the efficiency paradox, right? This notion that even though there are inefficiencies in the firm, why don't we see those inefficient firms disappearing? Now, the thing is that this particular kind of occurrence is so common that it's even got its own name, the efficiency paradox. The business literature is replete with examples of firms that have survived but still are not acting completely efficient in the sense that we might think a rational monolithic actor would act. How is that possible? Why would these firms still be in place? I'll just offer a couple of examples, and then I want to move on to my last point. One example would be the overall or average efficiency of the firm is adequate, right? That in reality, we don't actually have a survival of the fittest scenario, but what we have is a survival of the fittest enough, right? So it may be that the inefficiency created here is just simply not enough to make a difference when we look at all the other areas in which that firm perhaps is better than its competitors. The other possibility is that the stakes are just not high enough to affect survival, generally speaking. And then the last example may be that we're actually looking at evolution in progress, that we are currently transitioning from firms that don't make these types of green investments to firms that do. So we're just watching this in transition as it occurs. Okay, I want to make two last points, and then I think we'll be opening it up for questions. So far, I just talked to you about, are there situations in which we might expect to see firms passing up these green technologies that perform as well and cost less? But what about the possibility that even in the case where a risk management premium might exist, that you might still, at least theoretically, we might still see firms passing up these opportunities? And I want to just point out three things. As Steve explained, the notion of risk management as a driver in those circumstances, the risk management premium as driver in those circumstances, focuses on regulatory risk, the fact that you may be subject to further regulation, legal risk, that is, somebody may sue you, and reputational risks. So I'll just say a quick word about each of these. In the literature in each of these areas, there's a fair amount of empirical evidence and theoretical justification for the fact that actually regulation in many instances is simply not strong enough, and that enforcement of it is not consistent enough or predictable enough to be a driver in these types of situations. With respect to tort law, that is, getting sued by someone who has been harmed by your particular product, given the hazardous nature of the materials in it, one of the things we see in this literature about torts is that there are a number of structural features of the tort law that, while they may work well in cases of somebody falling in the supermarket or the occurrence of an automobile accident, don't work quite so well with respect to chemical exposures, given the long latency period that's required for the harm to become apparent, and the fact that tort law requires a showing of causation, which is very difficult to make with respect to chemical exposures. And then lastly, with respect to reputation, I think Steve makes a very strong point that if a firm has embraced safer, the advancement of greener technologies and sustainability as a central part of their brand and their reputation, we're more likely to see the risk management premium in action. The concern, of course, is that rather than a virtuous cycle in which sustainability and green, focusing on the green is deeply embraced and held as a sincere value, we also have to worry that many firms may see the claiming sustainability as a core value as very helpful, but not committed to it enough that they're going to protect it through the use by taking the charge against their profitability through the risk management premium. That instead they may engage in some sort of greenwashing to obscure the impact of the chemicals that they're using in their products. So what do we make of all this? If I'm right that there's a number of instances where failures within the firm, or perhaps we shouldn't call them failures, maybe just the reality of what happens when you have a complicated organization with information and coordination problems, what can we do then? Is it possible that regulation can play a role in terms of enhancing the adoption of these green technologies? And what I'll just end with is the point that, sometimes when we say regulation, we tend to think of it as, like we might think of the firm monolithically, we also think of regulation monolithically, that what regulation means is a ban on the use of a chemical. But in fact, regulation is more flexible and broadly based than that. And we can tailor regulation perhaps to focus on particular barriers to the adoption of green chemistry within firms. I'll give you 3 examples. Suppose that one of our problems is that the gatekeeper just cannot get access to the chemical ingredients in the materials that they are buying from other parties and incorporating into their products. What might regulation do in that case? So mandatory disclosure within the value chain is an example of regulation that could enhance the adoption of green chemistry by enabling the folks within firms to identify and propose the adoption of green chemistry. So we're reaching inside the firm not prescriptively, but actually as an empowerment to those folks within the firm who want to advance those goals. What about the problem of companies that have not focused on enhancement of their products? It's just not part of their core business function. It's not that they might stand opposed to it, but they just have not focused on it. Here we might have regulations that impose a planning obligation regarding alternatives, right? And we have examples of this type of program in effect in Massachusetts under their Toxic Use Reduction Act, which has shown that when you require companies to identify and look for alternatives to hazardous materials, that you see a reduction of the use of those materials, even among firms that haven't affirmatively identified that as one of their goals. And then we have the last case where there are company goals that are focused on profit rather than enhance public safety, and that's been a conscious decision. Not a problem of not having access to information, not a problem regarded to whether the attention or the agenda of the firm has even looked in that direction, but a decision to put profit above the possibility of enhancing public safety. And in that case, we might have a regulation that requires identification and then adoption of viable, safer alternatives, which is exactly what the case is in California, as the California Environmental Protection Agency is now implementing their safer consumer products regulations that take that form. And with that, I guess we're at the point where there should be a slide that says, oh, there it is, Q&A.
Okay, so let me, those were 2 great talks. So since we have a lot of shy students here, let me maybe open up with one question. Both of you focused on a reputational risk and brand capital. So the question is how to enforce or how to make that actually work. And I was thinking about 2 sides of the same question. Certification agencies. So when you travel around the world, it used to be that lots of companies, and I remember mostly in some African countries and Eastern European countries a few years ago, they proudly sort of showed that they were ISO certified, which means a certain quality level. In my experience, this is just an anecdotal, it seems that that has faded away. And so do you think that there is a market failure that we don't have enough certification agencies that come from the private sector, something like Moody's or Standard & Poor's in the securities business? And if that is the case, is there an opportunity for our entrepreneurship-minded students here to start a business that will certify the greenness of chemicals in different localities?
Well, I have some thoughts. Shall I go?
Go first.
Well, first of all, I think that's an excellent question in terms of certification. I'm trying to think of, you asked, is it possible that we don't have enough certification? And I think...
Let me add, I wanted to add one thing, just sorry for interrupting. Legally, can you shame the opposite, the other side? Can you have an agency that shames companies, or would that be illegal? Okay. So that's the other side. I mean, it's easier to shame the transgressors,
yes,
but it may be illegal. I don't know. I'm not a lawyer.
So why don't I take it? I'll take it from thinking about it from a regulatory standpoint, and I'll say a little bit about certification outside. So let me just take a couple quick things because I don't want to monopolize this. But one is, originally you said, is it a market failure that we don't have more certification or we don't have a prominence of certification? And I think it's a close question because actually my reaction to it is that we may have too much certification. So if you pick up a product now, there's so many different forms of certification on it, it's difficult for any of them to kind of have a resonance with the broader public. It will have resonance perhaps with narrower slices who are attuned to that certification, but if we're trying to move the general public, the more we have, there's a fair amount of information overload. And there's also concerns about how trustworthy this mark is versus another. And I think these are things that are difficult, things that can't be answered in response to one question. But there are examples of certification, such as one I think in the forestry area, and I'm forgetting now the name of the certifying agency, where the empirical work on it has shown that it seems to actually have had effect on behavior, right? So I think it can be done, but it has to be well designed. And the question is, whose behavior you're trying to change? The company that's getting the certification or the public that's making the decision? And I tend to think certification tends to work better when you're attempting to change the company's behavior directly. On the question of shaming, I think it is legal. And in fact, in California, that's an approach that they're taking as part of the Safer Consumer Products regulations, in which there is no authority under the existing program in California to require companies to actually test their products. It's a gaping hole in the program. But the way that the agency is dealing with that is they're making information requests of companies, and if a company doesn't provide the information, their name is posted on a list on the agency's website as a non-compliant company. And the goal behind that is that will drive companies, particularly those who have a concern about reputation, to turn over the information. Legal, yes. Effective, don't know yet. It's just starting, but I think that's one to keep your eyes on.
And I would just add that many NGOs make a living out of shaming organizations and pressuring them, encouraging their customers not to buy their products. Whether you look at, I'm not going to use a chemical example, but the export of seal products to the EU was basically halted through an NGO campaign. The export of wood products that were coming from a forest that some considered wasn't being sustainably harvested, was being clear-cut. So shaming campaigns, have a track record of success. I mean, not all of them, but there are some quite visible successes. So I don't think we've seen the end of shaming, and I don't think we should see the end of shaming. There's not enough shame in the world, I think. And too much shameful behavior. And on certification, I think that an important distinction to draw is between certification that works on a more B2B, business-to-business relationship, so the ISO standards, versus certification that is directed at the end consumer. And I think that the end consumer already suffers from information overload and is a bit overwhelmed. But I think the B2B certification stuff, specifically in the realm of chemicals policy, has potential.
It's a question to both of you, but I'm going to start my question with Professor Malloy. When you were talking about the regulatory environment, you were describing how there will be essentially an informational gatekeeper that will then isolate the department from certain information and certain incentives. And you recommend at the end of this that the regulatory structure should be one that encourages transparency between different departments and so on. But what Professor McGuire was talking about was a risk management that essentially makes the cost of noncompliance or something at the firm level. And so my question then to both of you is how to bridge the gap, how to make a risk management concept or structure that is at the firm level apply then at the departmental level.
Go first.
Well, it's, I mean, basically you're asking what can we do to align the incentives inside a firm so that the firm as overall behaves more like a rational actor. Well, organizational theorists have been wrestling with that question for a long time. When I was introduced, you heard that I teach a course on managing organizational politics, so it's a bit ironic for me to be on this side of the argument, arguing for a rational actor view, because I make most of my money explaining why firms aren't rational and can never be rational. If the risk is reputational, that works for firms that have a lot of their equity tied up in brand equity, a very strong brand. So I think that connecting the risk to something that is considered strategic, essential to competitive advantage, you'll get, even though there's organizational politics going on, you get more people's attention when you can link the issue you're trying to sell to something where it's very difficult to disagree that that's an important issue.
And I agree with what Steve had to say. And one thing I'll add to that, kind of from the regulatory standpoint. So, I'm the one who's making this claim that you can kind of carefully tailor regulation to kind of like a laser go within the firm and fix, in a sense, incentive structures and communication channels within the firm, right? So I posited that what I meant by gatekeeper is this is the person who would have to make the proposal to higher management to seek funding. And this person may not have that information. I don't necessarily think that occurs because sometimes it occurs because of misaligned incentives. Also, I think sometimes it occurs because at the firm level, the firm has not put into place effective management systems to get the information that person would need to make these kind of judgments, right? So if you're a regulator on the outside and your diagnosis is firms, I'm looking at how firms make decisions, and they're just not putting a premium on the movement of this information internally, you make it important at the firm level. So I'll give you the example of what's happening in California right now. this program I've talked about where the regulations are requiring performance of an alternatives analysis. So for certain chemicals of concern, in particular products, manufacturers are required to do an alternatives analysis. That is, actively seek out alternatives and evaluate them, right? This obligation occurs at the firm level, and there's an obligation that a higher level management person within the organization certify that they have in place reasonable measures to perform the AA, and that, right? So in New Jersey, where I come from, we call that the designated felon rule, that you're certifying to the government that you've got things in place. If you don't have the things in place, the responsibility for that rests directly with you, the person who signed it, and that gives a lot of incentive to make sure that throughout the firm you've got the management systems in place that make sure information goes where it needs to go in order to lead to this. I can tell you in a related area where the designated felon was used, rule was used not for alternatives analysis, but for just making sure people were complying with air pollution control permitting back in the 1990s when I was in practice. That made a difference because for the first time, firms I was counseling, I found upper level managers taking real interest in the compliance systems in place in the firm. So that's one way in which you might see something like that happening.